former President Donald Trump's bid to win back the White House is now threatened by two sentences added to the U.S. Constitution. 155 years ago, the Colorado Supreme Court on Tuesday barred Trump from the state's ballot under Section 3 of the 14th Amendment. It's the first time in history the provision has been used to prohibit someone from running for the presidency, and the U.S. Supreme Court is likely to have the final say over whether the ruling will stand. If it does, it's the end of Trump's campaign because a Supreme Court decision would apply not just in Colorado, but to all states. It also could open a new world of political combat, as politicians in the future fish for judicial rulings to disqualify their rivals under the same provision.
Before going into details, let us understand, what is Section 3 of the 14th Amendment?
Section 3 of the 14th Amendment was created to prevent former Confederates from holding government office. It disqualifies anyone who engaged in insurrection or rebellion against the United States or aided its enemies from holding office. Congress can remove this disqualification with a two-thirds majority. The provision was mainly used after the Civil War and fell into disuse after Congress granted amnesty to many Confederate veterans in 1872. The Colorado High Court's recent ruling on the provision may prompt the U.S. Supreme Court to take up the case, but predicting the court's decision is difficult. The provision has rarely been used in the 20th century, with the exception of a socialist congressman being refused a seat in 1919.
The recent ruling in Colorado may inspire other states to remove Trump from their primary or caucus ballots. While activists have requested this action, no state has done so unilaterally. Previous lawsuits failed until the Colorado ruling, which may prompt the U.S. Supreme Court to take up the case. However, the court's decision could vary, and experts caution against leaving such a significant constitutional question unresolved. Rick Hasen, a law professor at the University of California, Los Angeles, wrote shortly after the ruling, "It is imperative for the political stability of the U.S. to get a definitive judicial resolution of these questions as soon as possible."
Predicting a Supreme Court ruling is always risky, as the court's decision can be influenced by various factors. The current court has 6 justices appointed by Republicans, including 3 nominated by Trump himself. But predicting how individual justices will rule based on their ideology is challenging. Some strong advocates of using Section 3 against Trump argue that courts must follow the Constitution's actual words, and there's no ambiguity, Trump is clearly disqualified. The Colorado High Court's ruling was divided 4-3, with the majority citing a ruling from Neil Gorsuch, one of Trump's appointees, to support their decision. Courts are cautious about limiting voters' choices, and this has led to the political question argument, which suggests legal disputes should be settled by elected judges rather than unelected courts. This argument has been the basis for the failure of other Section 3 lawsuits. The Minnesota and Michigan courts allowed Trump to stay on the ballot, while a New Hampshire judge dismissed a lawsuit, stating the question of Trump's eligibility was non-justiciable.
Trump's lawyers argue that he isn't an officer under the United States, and even if he is, the January 6th attack wasn't an insurrection, and he didn't engage in it. State courts aren't in a position to determine if January 6th was an insurrection, and even if they did, it's a political question for Congress. The Colorado Supreme Court recently ruled that Trump is disqualified from the presidency, but the U.S. Supreme Court may take up the case.
It's worth noting that 3 of the judges on the Colorado High Court agreed with some of Trump's arguments. They particularly chafed at the rushed and improvised nature of the groundbreaking case, which was heard by a district court judge in Denver in less than 2 months. That included a week of testimony from a handful of police and protesters who were at the January 6th attack, 2 constitutional law professors and experts on a president's emergency powers and on right-wing political speech. Justice Carla Samauer wrote in a scathing dissent,
"If President Trump committed a heinous act worthy of disqualification, he should be disqualified for the sake of protecting our hallowed democratic system, regardless of whether citizens may wish to vote for him in Colorado."